Hello and greetings to Madam Ida Shafinaz. We would like to present our group assignment.
Assalamualaikum and hello everyone. My name is Raazerah Binti Nabi and my matrix number is BD331060992. Today I would like to present on IRAC 1 and 2. The first is liability of Minho for accepting an altered check, which is the issue is whether Minho over-received and bank a check that won't be materially altered is liable to return the 10,000 to Hyun Bin dispute the check bill cross not negotiable. Section 64(1) Bill of Exchange 1949 defines any material alteration to a check without all parties concerned voids the check. Section 64(2) Bill of Exchange 1949 gives specific example including change of date, amount, and payee's name. Section 81 of Bill of Exchange allows transfer of a check cross not negotiable, but a transferee cannot acquire a better title than the transferor. Under Section 29(1) Bill of Exchange 1949 state a holder in due course must obtain the check for value, act in good faith, and be unaware of defense like forgery or alteration. In Wilson and Manson v. Pickering 1946, a check altered by a clerk invalidated the receipt title even though she wasn't part of the fraud, which in this case would be fraudulently alter the name of payee from Sedapal Sendirian Berhad to his name. This constitutes a material alteration under Section 64(2) Bill of Exchange 1949, which renders the check void. The check was cross not negotiable, meaning Minho inherited a defective title from Woon Bin. Even if Minho acted in good faith, he failed to exercise due diligence given that chemical ink was used and the amount involved was significant. A reasonable person should have verified the check's authenticity.
In London and River Plate Bank Ltd vs Bank of Liverpool 1896,
bank that processed a material altered check was held liable. In Hepburn vs London 1921, failed to incur under suspicious circumstances disqualify a person from being a holder in due course. Augustine 2022 notes that transferees cannot hide behind good faith when constructive notice of irregularities exists. In Minho is liable to return the 10,000 to Hyun Bin, but the alteration of the payee's name without consent renders the check void under Section 64 and 2. The check was cross not negotiable, so under Section 81, Minho wouldn't acquire better title than Woon Bin. Minho's failure to verify irregularities, meaning he cannot qualify as a holder in due course under Section 29(1) Bill of Exchange 1949. IRAC issues 2 is liability of Rupa Bank for honoring a check bearing with forged drawer's signature. The issue is whether Rupa Bank, the paying banker, is liable for paying out on a check bearing a forged drawer's signature, even though the officer suspected the forgery and the check was crossed upon payee. So under Section 24 Bill of Exchange Act 1949 states that a forged signature on a bill, including a check, is entirely invalid, and the instrument unless the drawer or customer is stopped from denying the signature, such as due to negligence. Under Section 73A of the Bill of Exchange Act 1949, limited protection is afforded to the paying bank only if the customer knowingly or negligently contributes to the forgery, with the burden of proof resting on the bank. Under Section 78, state that a banker who pays a check in due course and in good faith may be discharged from liability, but only if the check is valid. In under Section 81A(1) of Bill of Exchange Act 1949, state a check marked account payee must be credited only to the account of the named payee. In this case, Woon Bin stole a blank check belonging to Hyun Bin and forged Hyun Bin's signature, a clear breach of mandate. Rupa Bank, as the paying banker, is duty-bound to honor checks only when properly signed by the account holder. The check carried a forged drawer signature, and meaning Rupa Bank acted without any authority to debit Hyun Bin's account. Miss Lazy, an officer at Rupa Bank, admits that he felt suspicious about the signature, yet chose to ignore the suspicious and proceed to cash the check. Rupa Bank, by disregarding a suspected forgery, breached its duty of care and cannot claim statutory protection. The check was also crossed with the words account payee, but Rupa Bank paid it in cash to Woon Bin, who was not even the payee. There is no evidence that Hyun Bin's conduct facilitated the forgery or amounted to negligence. In Greenwood vs. Martin Bank, 1933, the court emphasized that the bank's authority is derived solely from the customer's valid instruction. In Maliwa Apex Sendirian Berhad vs. Malayan Banking Berhad 2007, the court confirmed that the Section 73A offers liability limitation only if the customer negligence directly contributed to the forgery. In ML Breadworks Sendirian Berhad vs. RHB Bank Berhad 2014, the court held that if a bank fails to detect apparent irregularities such as alter or forged checks, it may be liable even if done in apparent good faith. According to the book Ellinger 2011, in Ellinger's modern banking law, a paying bank has a strict duty to verify drawer signature and is strictly liable if it pays on a forged signature. Rupa Bank is liable for wrongfully paying a check bearing a forged drawer signature. Since there was no mandate, no good faith, and no customer negligence, Rupa Bank must bear the loss and is liable to reimburse him. Next, I will pass to the third IRAC.
Hi, my name is Susan Ling and I hold the metric number BB221105111. I'll be presenting IRAC issue 3, which addresses whether Rupa Bank is liable for cashing a check marked account payee that was signed with a forged signature. Under Section 24 of the Bill of Exchange Act 1949, a check bearing a forged signature is completely void unless the drawer, which is the customer, is stopped from denying it. For example, due to their negligence, this means the bank has no legal authority to process such a check. In this case, Wubin forged Hyun Bin's signature on a blank check and inserted his name as the payee. This was a clear breach of mandate, and Rupa Bank should not have honored it. Moreover, the check was marked account payee, which is governed by Section 81A1 of the Act. This crossing restricts the check to being deposited only into the account of the named payee, but instead, Rupa Bank paid it out in cash, which is a double violation. First of the forged drawer signature and second of the crossing instruction. Also, the bank officer, Mr. Lazi, admitted that he suspected the signature was not authentic, but chose to process the payment anyway. This failure to investigate destroyed any claim of good faith, which is a requirement under Section 73A for banks seeking statutory protection. Looking at case law in Greenwood vs. Martins Bank Ltd, the House of Lords held that a bank is liable for honoring a forged check unless the customer was at fault. Similarly, in ML Breakwords vs. RHB Bank, the Malaysian court ruled that even apparent good faith does not excuse a bank from liability if it fails to detect obvious irregularities. Here, Hyun Bin was not negligent, and he gave no mandate for this check. Therefore, Rupa Bank breached its duty and is liable for the wrongful payment of 15,000 ringgit Malaysia. Next, let's discuss issue 4, which focuses on the legal effect of a check that was materially altered and marked not negotiable. According to Section 64(2) of the Bills Exchange Act 1949, any material alteration to a check, such as changing the name of payee, renders the check void unless all liable parties have agreed to the change. In this case, Hyun Bin had originally issued the check to Sedabah Sendirian Berhad, but Wubin altered the name to himself using chemical ink. This change was done without Hyun Bin's consent, so the check was legally invalid. Now, even though Min Ho later received the check in good faith, the check was crossed not negotiable, which is governed by Section 81 of the Act. This section means that Min Ho cannot acquire a better title than Wubin, who had no legal title to begin with. This follows the legal maxim, nemo that quod not habet. No one can give what they do not have. The court have upheld this in key cases like London and River Plate Bank versus Bank of Liverpool, where even a collecting bank was found liable for processing a check with a defective title. Also, in Wilson and Mason versus Pickering, an innocent recipient still could not enforce a material altered check. So, despite Min Ho's lack of knowledge about the fraud, the law does not protect him. He accepted a void check from a person who had no title, and therefore he also had no title. As planned by illegal in modern banking law, this rule protects the integrity of negotiable instrument and place the burden of the person accepting a suspicious check to exercise due diligence. Therefore, Min Ho cannot return the 10,000 ringgit Malaysia and the funds must be returned to Hyun Bin. Now, I will pass it on to the next presenter to present the final legal issues in IRAC 5.
Assalamualaikum and good day. My name is Nurul Shafiqah Binti Haniff with matrix number BD33103 We present the 5th IRAC. So, the issue is whether Roba Bank is legally liable for negligently collecting a materially altered check where Robert impersonated the true payee without verifying his identity. Under Section 85, Subsection 1 of the Bills of Exchange Act 1949, a collecting banker is protected from liability only if the check was collected for a customer, the bank acted in good faith, and there was no negligence. If any condition is not met, the bank loses this statutory protection and may be liable for conversion. This is supported by several case law. In Rubber Industry Replating Board versus Hong Kong and Shanghai Bank 1957, a fraudster deposited a check marked account pay only into a new account. The bank failed to verify his identity and was held liable for conversion due to negligence. On the case of Ledbrock and Co. versus Todd 1914, held a bank liable when it opened an account for someone without checking who they were. The court ruled that this was gross negligence. In Hampstead Guardians vs. Barclays Bank 1923, a bank was liable for collecting checks for a fraudster without verifying the account holder's credentials. Also under Section 64, Subsection 2 of the Bills of Exchange 1949, any unauthorized change to the payee's name is considered a material alteration. So, scholars like Paul 2018 further stress that good faith is not enough if a bank ignores obvious warning signs. Due to diligence is required to maintain legal protection. So, in this case, Robert altered a check made out to his boss Roberto by removing the letter O to impersonate the payee. This is a material alteration under Section 64, Subsection 2 of the Bills of Exchange Act 1949. So, Rupa Bank, through its officer Ms. Jana, allowed Robert to open a new account and deposit the check without checking his identity or requiring any documentation. So, just like in Rubber Industry Board versus Hong Kong and Shanghai Bank 1957, this lack of verification amounts to negligence and the bank lost its protection under Section 85, Subsection 1 of the Bill of Exchange Act 1949. Similarly, in Ledbrock vs. Todd 1914, the failure to investigate a new customer's identity led to bank liability. The same applies here, where Robert was a new customer and no checks were made. In Hampstead's Guardian vs. Barclays Bank 1923, the court emphasized that failure to confirm the account holder's identity amounts to carelessness. Rupa Bank's action fit this scenario exactly. Although the bank might argue it acted in good faith, Paul 2018 explained that ignoring red flags like a new customer, high-value check, and altered name is itself a form of negligence. This removes any defense. In conclusion, Rupa Bank is legally liable for negligently collecting a materially altered check. It failed to exercise due to care under Section 85, Subsection 1 of the Bill of Exchange Act 1949 and thus lost his legal protection. Based on the case law and statutory rules, the bank is liable for the conversion and must indemnify Roberto, the true payee. That's all for IRAC 5. Thank you.